Welcome to our session, the Scottish court system. Here we'll explore various aspects of our legal system in Scotland as it's implemented by the courts. So we're going to look at how the legal system operates, the structure of the Scottish criminal and civil courts, and this is really the extent of our criminal investigation for this module. And then we'll look at the key members of the legal profession in Scotland. And again, remember, this is just to give you an overview of the legal environment here in our country. At the end of this session, you should be able to distinguish between civil and criminal courts, understand the hierarchy of each, and be able to understand and describe the role of law personnel. You should be able to make the distinction between civil law and criminal law. And now this is much different than civil legal systems and the common law legal system, okay? So civil law here, we're talking about the rights and duties of persons, of people, individuals, and the disputes between those individuals. So it's individual against individual. Criminal law, on the other hand, is the state enforcing the law on people or persons. They prosecute crimes and offenses, and they also they look at conduct that's harmful to society. So they're going to penalize conduct that falls below the acceptable standard. It's very important that you understand this. Whenever you speak about criminal law, it's the state taking action against a person or a group of individuals. Whenever you speak about civil law, it's an individual or a group against an individual or a group. This is a chart that gives the structure of the court as it appears in your textbook. It's slightly changing now in both the civil and the criminal structure in 2016. And there'll be a 2-page handout attached to Campus Moodle for you to consult. But for examination purposes, it's this diagram and the information contained in the digitized chapter, which of course is also the Business Law Scotland 3rd edition edited by Gillian Blank. Anyway, here you see at the top. And remember, this is useful when you're thinking about precedent and stare decisis. So obviously, if a decision is created by the Supreme Court, then every court underneath it has to follow suit. They have precedent. And the stare decisis means that the other courts must stand by that decision. So the Court of Session, again, it's a civil court, as an inner house, is an appellate court. The Court of Session as an outer house is a court of first instance, which means that a legal action may be raised there for the first time. Then, of course, we go down to the bottom of the chart. You see the Sheriff Court for ordinary cause, and then you see the Sheriff Court for small claims and summary cause. These will be explained in a minute, what they mean. And it's all basically to do with the procedure, how much money it will cost to produce or enact the litigation. Small claims is the only time that an individual can represent themselves in court. Summary cause and ordinary cause both require lawyers, and the ordinary cause is the most expensive because it requires written pleadings. You can see that both, whether it's ordinary cause or summary cause, you can appeal to the sheriff principal, and then from there you can appeal to the inner house of the Court of Session. Let's look at that. We have 6 sheriffdoms divided currently into, for your textbook, as of 2015, something last year. This has been going because of financial cutbacks. There used to be 49. Now it's down to 39, and there's rumor that some more sheriff courts may be axed. Sheriff court can be a court of first instance and also an appellate court. The sheriff and the sheriff principal. Remember, the sheriff principal, there are 6 sheriff principals. They control or they oversee all of the sheriffdoms of each individual sheriffdom. The sheriff is then the judge. So there are many, many sheriffs, but there were only 6 sheriff principals. When it's the sheriff court like this, there's no jury. Because remember, there's never a jury in a civil action. So the sheriff court has exclusive and final jurisdiction for actions up to the amount of £5,000. And it covers these different areas. Of course, it's not exhaustive, but debt, damages, contract, delict, and family matters. So civil action, small claim procedure for up to £3,000 or that 10%, blah, blah, blah. And again, this is where you can actually represent yourself, and you can download the forms off the various judiciary websites, and it's fairly straightforward to commence these actions. Summary procedure, you have to have a lawyer for this, or solicitor, and it's for actions between $3,000 and $5,000. There are no written pleadings, so the lawyers just go in and start their verbal argument. So it's a lot more cost effective with that regard. But nowadays, if you've got to face it, £5,000 isn't a large threshold. So ordinary cause procedures for actions over £5,000. And so you will then see the distinctions about where you have to raise your action, whether in the sheriff court or the court of session, and then appealing, how you would appeal. And of course, these are always, if it's going to be divorce, of course, it's going to be more than £5,000. Or even if it's not, it's still ordinary cause, bankruptcy, succession, and adoption. They have to be ordinary cause. So you have to have a lawyer, you have to have written pleadings, and it's expensive. So civil actions, this is about the amount of monetary thresholds. I think we're well overdue a new change. The monetary thresholds really aren't adequate. Also here, it's important to remember that the court structures, again, I thought of adding it to the slide, but I thought I'd just, instead of printing on, I just mention it. I'll mention it in the lecture live as well, that the court structure is changing in 2016. Your book hasn't been updated, and I went on the website, spent a day searching, and it's very unusual to find an up-to-date web page. Even the judiciary web pages are still featuring this, the current structure that you've just seen. So, and your book, of course, the digitized chapter contains that with a little note saying it's going to change. So for our purposes, we're still sticking with the previous. And again, this is just an overview course, so there's no point in getting too technical. So the Court of Session is the highest civil court in Scotland. It covers all of Scotland, and it has concurrent jurisdiction unless prohibited by statute. That means nobody else can do it. Exclusive jurisdiction, so concurrent means that it could be either the sheriff court or them. Exclusive jurisdiction for an action reduction, that's if you're in a contract and you want to get it. When we speak about void and voidable contracts, that's what you would go for. Actions for proving tenor of lost documents, not an easy thing to do. Petitions of winding up a company, international child abduction cases, and of course, judicial review. The outer house is a court of the Court of Session, is a court of first instance, so you can raise your legal action there, as opposed to raising it in the sheriff court. The judge is named or referred to as a Lord Ordinary, and he sits alone, or she sits alone. All civil claims, unless they're excluded by statute, can be heard here. Industrial actions or defamation may have a jury of 12. It's very rare, but the rule of thumb is that there just isn't a jury in a civil case in Scotland or England. And that's one of the reasons why our awards that come when people commence litigation, and at the end, the rewards tend to be lower than, say, in America, where you have a jury in that instance, and they get very emotional and charged. And also, we don't allow penal sanctions. We don't have our damages are awarded to as a compensation to restore the person who suffered the wrong to the place they would have been in had the wrong not occurred. There isn't a penalty element to it, whereas in the United States there is. The appeals are to the inner house. And there's a case that will just give you that. That link worked, but I put it on, as usual. If it doesn't work, just Google it if you're really that interested. The inner house has 2 divisions of equal stature. One's called the First Division, and the judge is referred to as the Lord President, and 3 senior Lords of Session set in there. The Second Division, equal stature, remember, is the Lord Justice Clerk, or Clerk, and 3 Lords of Session. It's primarily an appeal court on a point of law. In revenue cases and special cases, it can be a court of first instance. Doesn't happen all that often. The Supreme Court, now this was reformed under Tony Blair. It used to be known as the House of Lords, as a court. And there was a great deal of confusion among the population as to what this court was. They kept, a lot of people thought it was all those gentlemen and ladies sitting in ermine gowns in that big, gigantic chamber. And historically it was. But in the past several hundred years, that hasn't happened. And it's very important for you to realize that that's why the name was changed. It was to reflect the fact that it really is the highest court in the land. And it was very important, a lot to avoid public confusion. They chose the name Supreme Court. It's a bit American, but, well, that's that. It assumed the judicial function of the House of Lords. It's an appellate court. And, of course, all the people that sit as judges are very, very highly qualified members. They always have been. They're previously known as law lords, now they're justices, and there's usually 3 on the bench, or 5 or 7. It's not unusual. The more serious and the more likely the decision in this case, or the case being heard, will change the status of the law, the larger the number of justices will be on the bench, so as to get a good balance of opinion and to push weight behind that decision. There's a couple of different things. They're interesting, I guess. So in civil procedure, what's your proof? Any fact that's admitted doesn't need to be proved. And that's a thing you do beforehand, before the trial starts, before your action starts. You want to get anything that's admitted out of the way so you don't have to go through all the things like, I admit I'm Eric Ogilvie Brown, I admit I work at the Robert Gordon University, things like that. Get rid of all of that and let's get down to what's at dispute. There are no opening speeches. There's none of this and blah, blah, blah. The judge knows what's going on. You don't have to brief the jury because there isn't one. So you just get straight right in. The pursuer, that's the person that's instituting the action. They call witnesses and examine them, the defense cross-examine. You've seen this in the movies and the blah, blah, blah. It's exactly like that. When it gets to the end of it, both sides then do a closing speech. And the judge may either give the opinion straight away or can wait for later. Because what happens, sometimes the judge will retire for a period of time, of whatever length they feel is necessary, so they can consult various legal sources. They can go to their offices, their chambers, and consult various legal books and other documents. And it can decree grants or refuse remedies sought by the pursuer. And then after that's over, that's when they hear motions regarding expenses. It can be very expensive, especially usually the person who loses pays, if not all of the costs, a fair chunk of them. Civil appeals only on a point of law. Points of fact, evidence states ascertained by evidence, that would be miscarriage of justice. Point of law is the existence or applicability of a principle rule of the legal system to show that the law was incorrectly applied or that a law wasn't cited and it should have been proved by legal evidence. So let's look at the Scottish criminal courts. And again, remember, this is changing as well. It's supposed to be streamlined. So we've got at the bottom, it used to be called the district court, now it's the Justice of Peace Court. And then the Sheriff Court, and then the High Court of Justiciary. Now, it's important to remember that, in 1707, in the Act of Union, Scotland did not give up its criminal justice system. So there is no appeal from the High Court of Justiciary to the Supreme Court. That's it in Scotland. It's the High Court of Justiciary as an appellate court. That's the court of last resort for a criminal matter in Scotland. So that's the hierarchy of it. And you can see, again, for precedent, if it comes from the appellate court of the High Court of Justiciary, that's the highest decision in the land. And it binds the trial court, the sheriff court, and, of course, the Justice of the Peace Court. Solemn procedure, that's with a jury. So it's trial and indictment. Jury of 15 and the judge in the High Court of Justiciary, sheriff or sheriff principal, and a jury of 15 in the sheriff court. Summary procedure means without a jury, and it can be on trial on complaint. And again, it would be the sheriff or sheriff principal in the sheriff court, or a JP or stipendiary magistrate in the Justice of the Peace Court. These are, I think it says in the next slide, these are paid legal personnel to come in. There aren't very many of them, and it's gradually being phased out as well. The district courts have been phased out to be the Justice of Peace Court. Minor crimes like breaches of the peace, road traffic offences can be heard here. Summary procedure. So it's jurisdiction and administration, you can see what it covers. And then, of course, who is the Justice of the Peace, the JP? It's a layperson. That means any member of the public could be a justice of the peace. They get some training, and there's a legally qualified person there to advise. The maximum sentence they have is 60 days. It has become 6 months. It's 120 days, 180 days. Sorry, I'm not very good at math. I'm a lawyer. And of course, it's for anything that fines of 2,500 or less. Stipendiary magistrate has the same status as a sheriff. Sitting in summary procedure, and of course, they can impose a fine of up to £10,000, and they can also imprison someone for 12 months. There are only 2 sheriffdoms that have stipendiary magistrates right now. Anyway, the sheriff court has jurisdiction over all crimes like treason, murder, rape, and incest. Now it's known as treason, murder, rape, and other sexual offenses. A summary procedure, again, will be a fine up to $10,000 or 12 months imprisonment. You can see the similarity between a lay stipendiary magistrate and a sheriff here, similar amounts of penalties. Under solemn procedure, unlimited fine and up to 5 years imprisonment. And of course, they can also refer it to the High Court of Justiciary, for if a tougher sentence is merited. So they can actually say, we've tried this, we found you guilty, but for sentencing, you're going to go to the High Court of Justiciary to get sentenced. Not so much fun. The High Court of Justiciary is the highest criminal court in the Scottish legal system. It operates as a trial of first instance and as a court of appeal. And it's the same judges from the Court of Session also sit in the High Court of Justiciary, but they have different names. The judges are called the Lord Commissioners of Justiciary, and the Lord Justice General presides over the High Court. As a trial court, it sits in Edinburgh, but it also goes on circuit throughout Scotland. And this is dating back historically. It's a very, very good principle because the modes of transportation were not great years ago, especially 100 years ago or 200 years ago. It was important that the public saw justice being done. So the court would travel to the areas around Scotland where the crimes had been committed, and the courts would be held in major cities or locations of prominence. And it was so that the public could see the accused being tried and to see that justice was fairly being distributed, and also so they could be tried by a jury of their peers. So it has exclusive jury over all these fun things here. As a trial court, solemn procedure, and it's trials heard by 1 judge or 3 and a jury of 15 citizens. Sentencing power is only limited if a statute says there's a maximum sentence. And of course, from here you can appeal to the High Court of Justiciary. It's the same court, but it's acting as an appellate court. And at that time, sitting as a court of appeal, it's only in Edinburgh. It doesn't go out on circuit. It sits only in Edinburgh, and it's only judges. It's heard by 3 or more judges. And again, it's against the sentence or conviction or other order of the court. And of course, this will look at any miscarriage of justice as well. Sitting as a court of appeal, the Lord Justice can appeal against the sentence if it's too lenient. And as you can see, only on conviction, no jury allowed. It can dismiss the appeal or uphold the appeal, of course, or a retrial, which is interesting. There are also these things known as tribunals. These have become much more popular. They're quasi-legal, and they were originally created to be less expensive. As time has gone on, they've gotten more and more expensive, but it's a faster way and less informal, less adversarial way of settling problems. We've all heard of different tribunals. You can read those for yourself. Moving on to the legal profession, we have solicitors, advocates and solicitor advocates, and qualified conveyancers and executory practitioners. So these are the last one, the conveyancers and executory practitioners. They're non-legally, they don't have a law degree, but they have a certain qualification in their specialist area. Conveyancing would be for sale of property. Executory is for wills. A solicitor is a qualified legal individual who has an LLB. An advocate is someone who also has an LLB but is specially trained in litigation. And a solicitor advocate is a hybrid between the two. Solicitors, they have to have a law degree, then they have to get a diploma in legal practice, which takes 1 year. And then they have to undergo a 2-year traineeship, which is like an apprenticeship. And then they have to renew their annual practicing certificate. That's after they've completed those. So an LLB can take 3 or 4 years, then another year for that. So it's quite a long 6 or 7 years before you actually become a qualified lawyer. And the Law Society is the governing body. And, of course, it's important to remember that a solicitor has no right of audience in the Court of Session or the High Court of Justiciary or the House of Lords. To do that has to be an advocate, and it's being known as being called to the bar. Qualifications, again, are an LLB degree, and then they go through this training and examination period known rather charmingly as deviling. It has the right of audience in all Scottish courts and, of course, the Supreme Court. And they get instructed by a solicitor. So when you need to get an advocate, if you're going to go to the Court of Session or the High Court of Justiciary or the Supreme Court, you have 2 legal bills. You have a solicitor's bill because they're the person that the legally qualified individual you'll seek out, and then they will then communicate with the advocate. And years ago, it was quite common for the advocate not to actually have met their client until they're actually in court, because it was up to the solicitor to do all the other things. That's changed a wee bit. And Queen's Counsel QC, that's known as taking the silk. You have to have a minimum of 13 years experience, and you're recommended. It's rather prestigious. And, of course, if there was a king on the throne, it would be KC, King's Counsel. Advocate deputies are the same as procurator fiscals. They have that right to appear in front of those certain courts. Solicitor advocates are this hybrid between a solicitor and advocate. It has to be a qualified solicitor with so much experience, pass these exams, and then can go on, and then has this right to appear in all the courts. And it's an advocate can appear in all the courts as well, but it's the first time that solicitor now can go to the High Court of Justiciary, I love that word, or the Court of Session. So it's very interesting in that regard. It's supposed to reduce legal bills. So looking at the judiciary, we have justices of the peace, stipendiary magistrates, sheriff principal, judges of the Supreme Court of Scotland, the senators of the College of Justice, that's in the Court of Session, Lord Commissioners of the High Court of Justiciary, Lord President, Lord Justice General, and the Lord Justice Clerk. The law officers, the law advocate, the Solicitor General, the Procurator Fiscal, and, of course, the Advocate General. I suggest that you look these up in the book, in the digitized chapter, and get a definition of each of these, that one and this one, for yourself, so that you're aware of what they do and their function. It's not an onerous task. It's not egregious. It will take you about 5 minutes, but it just gives you a little bit more hands-on. So it's interesting about prosecution. The police investigate crimes and gather evidence, but it's the Crown Office and the Procurator Fiscal that are the ones that decide whether or not to bring forward a prosecution. And so you can see now exactly how that is done. The law officers here are the Lord Advocate, the Solicitor General for Scotland, and, of course, Advocate Deputies and Crown Counsel. And, again, that's for High Court of Justiciary. And, of course, the Advocate General. Another thing that's come along, another type of legal solution, would be an ombudsman. And they're rather new to the UK scene. They've been around now for about 10 years, but in legal terms, that is new. It's not a court or tribunal. They just investigate and they resolve complaints against individuals. The Information Commissioner is probably the one that most of you will have heard of, or may even have had personal dealings with. That's under the Freedom of Information Act. That's the office that will deal with complaints when a public body that you've asked for information under the Act fails to provide the information or an adequate response. And, of course, the other ones are fairly straightforward. That concludes it. I realize that was a bit fast, but the technology has been problematical once again. Go through the slides, the printer-friendly version, look at them. Please do read that chapter in the book and go through the notes. And also just be aware that the court structure is changing. It's just for your own personal information. Okay, and thank you very much. And I'll go through the rigmarole of stopping this now.